The biggest story so far about the Roberts Court is the court's rulings for corporate America and its new polarization on these subjects. It's not that the Chamber wins every case. They lose cases every term. They will lose cases this term. But in the last 5 years, they've won over 2/3 of the cases they participated in before the United States Supreme Court. Second, it is absolutely clear that the enormous efforts the Chamber of Commerce has put into litigation and the courts over the last several decades have succeeded in making the courts more business friendly.
First, I'd suggest throw out the term judicial activism. The term is, whoever uses it, means the same thing, and it descends into what a playground argument is about. You're one, no, you're one too, or whatever. You're just talking, when you use the term, you're just talking about things you don't like. Not whether a decision is correct, or more important, whether it's durable, whether it'll be respected. But there's a different place to look, and admittedly it's a controversial place to look, and that's the question of access, the expensive lawsuits, and that many of the cases that you're criticizing have to do with businesses winning because businesses are the defendants in the case, and that litigation is increasingly expensive.
I just have to agree with what Stuart said about the tremendous conflation that is going on here. Believe me, I spend my life as a full-time critic of, in particular, decisions by the Supreme Court. But what bothers me about your presentation, Doug, is the demonization of the Chamber of Commerce and the assumption that just because the Chamber of Commerce is in a case that therefore is pro-business and anti-every other positive. First of all, that business is negative and that therefore other positive interests are adversely affected.
Yeah, there's a greater percentage of cases that are business cases, and that's perhaps because of the trend that the Roberts Court, as John Roberts said during his confirmation hearings, that he wants to get back more to the court's bread and butter issues rather than to the headline-grabbing kind of one-off constitutional things that were part of the court before, for better or worse.
The Chamber's mandate is to represent the unified interests of American business. It only files cases where it thinks that business interests are acutely involved. The Chamber's success is the culmination of a 30-year project that began, as Doug said, with Lewis Powell's memo in 1971, which resulted in the cultivation of advocates like John Roberts, who worked for the Chamber before joining the court. It has to do with the endorsement of justices like Justice Breyer, who share a suspicion of regulation by litigation, so that there's not a single justice on the Roberts Court who embraces the economic populism of William O. Douglas.
There's an intellectual myopia to the whole question that we're considering today that makes me very uncomfortable. If businesses won when they shouldn't have won, that would be a story. The mere fact that business won doesn't really tell you a lot.
Is there any member of the Supreme Court who really believes that jury trials in civil cases are a good thing? Isn't that the problem? That we have gotten judges and corporations and the general public thinking that a basic constitutional right is stupid and produces crazy results, and we don't want to subject ourselves to the possibility of that kind of result.
I think the Chamber's brief at the petition stage could be an important signal. But really, what we're dealing with here are 9 lawyers. Maybe Ruth Bader Ginsburg is interested in preserving the jury trial, but I don't see too many others on that court right now who are not fundamentally suspicious, skeptical, or even hostile to litigation.
And this court did not have to reach out to make that decision, not on the basis of the petition to cert that was sought by the prevailing party in the case. They did not seek that kind of review. You know they didn't seek that kind of review. The Supreme Court then went back and said, we want this question answered because we want to decide it the way we want
because
to
we
do
want
it.
to restore it.
Our question is,
now
why is
out in the pasture.
Yes, exactly. No, our question is, why is it that Justices Roberts and Alito, who are not noted civil libertarians in other cases, join the majority in this broad recognition of corporate personhood? And the truth is that there are 2 different strains, maybe 3 different strains of legal conservatism on the court, which I had not appreciated when I and others talked about a pro-business trend. On the one hand, there are the pro-business conservatives like Roberts and Alito who want these broad national rules like preemption. Then there are the states' rights conservatives like Justice Thomas, the Tea Party conservatives, who sometimes are on the other side of the preemption cases and actually favor jury verdicts because they believe in principal terms that the states should rule. And then there are the libertarian conservatives like Kennedy, who favors the Cato Institute, will vote to strike down both gay marriage and health care, using the same Lochner-esque free-floating autonomy rights in both cases that are broadly sought. I just want to push this over.
That's what's changed. There's kind of an East Coast domination of the Supreme Court, reflecting a different kind of conservative sensibility among conservative justices that no longer reflects this tradition that had actually been on the Supreme Court, not just in liberals like William Douglas, but these other justices who never thought corporate speech in the electoral context had First Amendment implications.
People demonize the chamber and its take on wherever it plays, whether it's in the courts or in policy arena, because the chamber fundamentally isn't what it says it is. I mean, when we talk about this being a success strategy of a unified business approach to the courts, that's just not true. I mean, the chamber doesn't represent a unified spectrum of business. It is overwhelmingly dominated by a very narrow class of businesses, and within those businesses, the corporate management of those businesses, at the expense of shareholders and every other kind of business. So the reason that the Citizens United decision and others feel so wrong is that it is the court taking the interest of what is perceived as a new American aristocracy of the corporate management class, and they're taking that decision at the expense of everyone else.
I can talk about the Court of Appeals. What we have in the Court of Appeals is a documentation that was done by law professors at Cornell, Stuart Schwab, who's a dean at Cornell, and Kevin Claremont, that I've testified about in front of Congress, which is that they documented that on the trial court level, when employees win at trial, or put it this way, when employers win at trial for businesses, they get reversed 8% of the time because there's a lot of deference to the fact finder. But when the employees win a trial, they get reversed over 40% of the time, a 5-to-1 difference. An enormous double standard. That's Federal Courts, Inc. That's the title of this panel. That's what really shows, I think, that the business community is having an undue influence in our federal courts. And my own view of this, which I brought up again in the same testimony in Congress, is that we have to look at who is getting appointed to these courts. And there's a high proportion of people that are being appointed who are former prosecutors, or former corporate counsel, very few people who are public defenders, let's say, or have worked at labor organizations, or have worked at public interest. So we're just drawing on narrow pools of people from the bar and missing perspectives from other highly touted and respected parts of our bar.
Go ahead, Wayne.
Well, a couple of strands that come together here are the anti-litigation bent of the courts and the anti-individual bent of the courts, and they come together in the issue of mandatory arbitration, where the courts over the last 20 years have consistently and broadly excluded whole classes of people from being able to bring their cases to court, particularly employees and consumers. And the double whammy on this, though, is the recent trend of companies to force cases into arbitration, and then to say the arbitrators cannot pursue, can't entertain class or collective actions, thereby eliminating completely the ability of the consumers and the employees to participate in class and collective actions.
Winning cases. When Twombly retired Connolly against Gibson, that wasn't an act of judicial activism, it was judicial mercy. Because people were walking into court with, handwritten documents. Cases, including the Second Circuit, held you don't even need to plead the elements of a claim in order to impose all these costs. So I must say that none of the arguments that I'm hearing suggest that we're anywhere near close to federal Inc.
Everyone is talking about the courts as though they are a political branch of the government divorced from parties and underlying statutes and rules of procedure and so forth. I mean, there are questions like, don't the courts just hate litigation, and don't they, hate jury trials and whatever? Every case involves a statute, a rule, something, two sets of arguments by two parties. It's not as though the courts gets a free flow to decide issues, but that seems to be getting lost in this discussion of do judges hate business or like business or what?
I think that we should focus on some of the cases specifically outside of Citizens United and take a look at cases like Twombly where they reversed at least 50 years of precedent, cases like Penn Plaza, which was a civil rights case where they reversed 30 years of precedent, Ledbetter where they reversed 50 years of precedent. The Exxon and Philip Morris cases on punitive damages where the Supreme Court reversed at least several hundred years of precedent by saying that the Due Process Clause of the United States Constitution imposes a limitation upon state juries' right to award punitive damages. I'd like to know where in the language of the Due Process Clause that any such limitation can be found by a strict constructionist. The Legan case, where they reversed 100 years of precedent on price fixing. The Morrison case this last term, where they reversed 50 years of precedent interpreting the securities laws. The Supreme Court has got a case this term, the Janus case, which if their decision in Stonebridge is any indication, the issue is whether or not a person, the statute says you have to make a statement. The Supreme Court is deciding the issue as to whether or not that means that the statement must be attributed to the person in order for it to be made by that person. Would anybody like to take a pool on whether the Supreme Court interprets the word make to mean directly attributed, including the members of the Supreme Court who advocate strict constructionism? So, I mean, those are just a sample of some of the cases. You can go through, well over a dozen cases in recent years where the results are just an absolute stretch. And the reason why the statistics resonate, the reason why people feel that the statistics have some validity is because of the underlying story told by the cases.
But I think the key point here is that most of these cases are about statutory interpretation, and the thing that has changed over the last 40 years is that this court and the one before it said Congress has got to create these remedies, and they've got to do it in pretty clear terms. Plaintiffs can't come to the federal courts and say, liberally interpret all these laws so that we can proceed with our claims to the end and get the maximum amount of damages. This court has said Congress has got to do this through a democratic process. It's got to make it clear that they intended this remedy, and when it does so, we'll enforce it. And they do, as they show time and time again. They will give the remedies when Congress says so.
The only slight change I would make is that there's a focus on the Roberts Court, which is important. It's what we're wrestling with, but it's part of a longer trend. I think Elliot Spitzer earlier said that we've had 30 years of an ideological run. And I would argue that there are a number of significant cases having to do with whether it's business or access to the court that have occurred over the last 10, 15 years that are the result of this 30 years of ideological run as they've affected our courts. Cases like Sandoval, which inhibited our ability to go to court to enforce civil rights law. Cases like Iqbal, like Hoffman Plastics. A whole range of cases that together reflect a trend. I also wanted to suggest that that trend then in turn affects society.
Courts, the federal courts, including the Supreme Court, don't decide cases in a vacuum. And I think it's true that the conservative movement, which is represented by the Republican Party, is making a concerted effort. And this effort is being funded on almost an unlimited basis by big business. And that's to reverse every social, economic, and political advance that took place in the 20th century and which made America the beacon of liberty and hope in the world, and which represented the greatest era of progressive change in the history of the country. And I think we have a very determined political movement to reverse that. And it's using all available means, including the courts. And the courts have been highly politicized. Their independence is a joke. And they have, this is one area in which the political process has, resulted in the greatest success for the conservative movement.
I'm one of those securities practitioners, and I would like to go back to a point that Jay raised, which is, I think, in addition to the very learned commentary that we have on numbers of cases, won, lost, whatever, by the chamber. If you look at the actual cases themselves that are now being brought to the court, a woman earlier said that if a plaintiff wins in the Court of Appeals in a business case, the Supreme Court is going to take that case. And in fact, they did in the case that our firm has been handling, the Janus case. So the Janus defendants went to the Supreme Court and they said, oh, this is horrible. All of these people, all these lawyers who help these mutual funds will never again work for a mutual fund if they think they're going to be liable. And the chamber came in on their side and the government came in on our side, and the Supreme Court took the case. And the case was argued in December. And the essence of it is that they're arguing that a wrongdoer who lies about what he does should be exempt from liability. This is not a bystander. This is not an aider and abettor. This is the actual company themselves. And it got a very nice reception by at least 3 of the justices in the Supreme Court. We don't know what's going to happen, but we think we did the best we could. I think that's illustrative of the kinds of cases that they're taking, which I think definitely undercut, as Jay said, 50 years of jurisprudence.
To keep it. At every phase of the judicial process, there have been additional barriers put up to keep plaintiffs from prevailing. And that is almost, while there are many small businesses, that, unlike what Steve said, many small businesses would like to have a jury trial. And a lot of things happen to them. Every one of those barriers has been in the interest of big business. And it's kept people from getting to court, and when you get to court, it's kept them from advancing their rights. And that's it.
But sort of stepping back from that, I think the sense of a lot of people in the environmental community is that this court has sort of reached out to grab environmental cases in a way that perhaps we hadn't seen before. And I would note, and again, all of this sort of depends on how you do your math, but something like a third or thereabout of the cases this court has heard have had a constitutional dimension of some kind. So these are not all just sort of routine statutory interpretation cases. And case in point is this American Electric Power versus Connecticut case that's shaping up to be sort of the big environmental case going forward. I mean, here you have a case that sort of represents a set of cases, these nuisance cases to challenge greenhouse gas emitters and come up with some kind of a climate remedy in the courts, if you will. And most people have not given these cases a high likelihood of success on the merits, and yet in the absence of a circuit split, you do have the Supreme Court pulling this case in where there's a very prominent Article III standing issue and a very prominent political question issue, both of which obviously can have far-reaching effects. So I think this access question just comes up again and again for us, and it's a real concern.
I look at these cases individually. I think these are good cases. I think these Rule 8 cases, I think on the face, I'm in favor of them. And Jay's probably shuddering back there as I say this, but what bothers me, and what I find that I end up being concerned, then is who is applying these decisions and rules, and how are they being applied after they're laid down. I look at these cases, they look fine to me. What happens next as they're applied in a circuit or district court, I find more troubling. So I think that really what we cycle back to is something that only a few people have stated so bluntly, and it is that this ends up being, I think, politics. I think people in this room tend to be disturbed about this because of who's making the decisions and the results that come down, not because of the rules. And I'm coming right back to Stewart's opening statement when he says there's a conflation of jurisprudence and politics. And I think that's right, though I think that conflation, Stewart, happens on the bench by judges who actually do that conflation, whether they even recognize it or not.
The cases are so result-driven with so little intellectual honesty. And what comes to mind for me is the Kmart decision. In Kmart, that was one of the biggest accounting frauds in the 1990s. There was no question it was a fraud. There was a huge restatement of financial statements. It came after some whistleblowers had tipped off the SEC what was going on. There's no question that an investor who purchased that stock, when those financial statements were inflated, paid too much for that stock. But because the fraud wasn't revealed until after the company was in bankruptcy, there's no case. And as a result of Dura, and even leading up to Dura, more and more corporations are getting more and more clever about how they announce decisions. You'll never get a pure announcement of bad news anymore. It'll be buried with an announcement of 4 other things of bad news, so that when the plaintiffs bring their case, the defendants can say, well, look, you can't parse it out and say what caused the damage, so no case for the plaintiffs. And that's a long-standing trend. That goes back to the central bank case 20 years ago.
I think what makes a court, an activist court, are a number of factors. It's not any one thing, but it's a court that's willing to overturn precedent, a court that's willing to overturn acts of Congress, a court that's willing to decide issues that are not before them, a court that's willing to decide factual disputes that are traditionally left to the jury, to the lower courts, or in many cases with the current court, even to Congress. I mean, they make factual determinations that are contrary to findings of Congress, and particularly in the Supreme Court, it's an activist court, and Ed said this, Sandy said this, other people said, because it has been reaching out to take cases that, under established precedent, it should not take, and it doesn't need to take.
It really is taking any advantage to find a ruling that is consistent with a political outcome, not necessarily with a legal construct. Again, it's opportunism rather than constructionism.
And I would like to kind of stop seeing ourselves as victims of this decision and say that we should accept its invitation to, if corporations are going to participate in democracy, then democracy should participate in corporations. And the corporations should answer to their shareholders. And the shareholders are the public investors, who are often comprised of public employees and labor. And we should stop seeing ourselves as victims of circumstance and see ourselves and make the rules responsive to the owners of the corporations, which are the public pension funds. While the CEOs of the corporations that the public pension funds own are still taking home tens of millions of dollars, and there has been no accountability.
Right? And let's ask this court that finds a right to be free of excessive punitive damages somewhere in the Constitution, and then looks at the 8th Amendment, which actually says cruel and unusual punishment, and says, you know what? Basically, any sentence that the legislature comes up with is okay. So you tell me what the principal theory is there. You tell me, in the pleading cases, for 40 years the court says, we're not going to alter pleading unless Congress tells us to, right? That's the principle. Congress has to tell us, or the rules have to tell us. You tell me what the principal distinction is when Twombly and Iqbal comes along, other than some assumption, some empirically false assumption about costs and about the relationship between merits and pleading. As an empirical matter, everyone's been assuming there's some relationship between the thickness or thinness of pleading and merits. As an empirical matter, it's never been demonstrated. As an empirical matter, in fact, the only empirical literature on it says that there is no relationship. So look, tell me what the principle is, and I'd be happy to agree that there's a principle of court here. I just don't see it.
I think progressives do rely too much on precedent and say, this is overturning precedent, this is wrong, this is bad. We don't argue enough about how wrong some of these opinions are as an original matter and as a matter of text and history. And so we talked a lot about the jury trial. Look back at the framers. There is no institution whatsoever they cared about more than the jury trial. The right has created this whole panoply of obstacles to access to court around the flimsiest text of Article 3 and the case or controversy, whereas the jury trial is built into the original Constitution and 3 of the 10 members of the parts of the Bill of Rights.
I think, when Citizens United upheld disclosure laws, it upheld disclosure laws only at the back end, at the level of the individual ad. So thanks to, the court's decision, we now know that Americans who love America pay for a particular ad. The problem is we have no idea who Americans for America is. The tens or hundreds of millions of dollars that were spent in the
Sarah Palin's PAC, right?
Exactly. To quote Arthur Miller. So of the tens or hundreds of millions of dollars that were spent in the midterm elections, about 30% of that money was dark. We have no way of finding out whether a corporation or whether anyone paid for that. This is what the court did when it assumed in its decision that corporate spending is disclosed to shareholders and to boards, when in fact BP's own shareholders, BP's own board of directors do not know whether BP spent money.
But the thought that I think we have a serious issue at stake here about whether we have judicial nominees coming through who are sensitive to what ordinary Americans face. And whether at this time of great crisis in this country, where you have billions of dollars of profits coming through, but so many people unemployed and shut out of the system, worried about whether their health care is going to be reversed by this court, and worried about whether their right to organize or bargain has been pretty much rid out of the system because of the fact that people mentioned the Court of Appeals are reversing, do not give Chevron deference to many of the NLRB decisions coming out when unions or workers win. Those are serious questions for our democracy. And I really urge that we step back for a minute and think about what the damage is if we don't have judges on these courts who are seen as representing and understanding what ordinary Americans face.
Just to sum up briefly, there was an omnipresence brooding over the end of our discussion, and that was the ghost of Lochner. There have always been Lochnerites among conservatives. Richard Epstein, Randy Barnett have unapologetically embraced libertarian judicial activism on the basis of rights that are not textually enumerated in the Constitution. But the conservative judicial movement, the mainstream movement, was supposed to have rejected that. At a debate with Richard Epstein at the Cato Institute in 1980, when Epstein called for a resurrection of these atextual doctrines to strike down the regulatory state, Scalia chastised him. He said, conservatives made a mistake in Lochner. We should recognize that political regulatory debate should be solved in the political arena. We shouldn't succumb to the temptation of liberal judicial activism. By any measure, that is exactly what conservatives are doing now when they call for health care to be struck down. You saw that Professor Charles Freed noted that this is not a federalism issue. This right not to be forced to buy insurance or to buy broccoli, said Freed, is a free-flowing autonomy Lochner-esque right not to be forced to do things that don't affect other people. I think if the Supreme Court, goes down this route of resurrecting Lochner, striking down health care, striking down campaign finance, it will join a long progression of previous conservative courts that have tried to strike down progressive regulations from the income tax to the New Deal. But we know how this story ends, and it never ends well for the court.
I want to thank this incredible panel.